All right, let's jump right into a classic contract law case, Hamer versus Sidway. Now, by the end of this, you're not just going to know the story. We're going to break down the exact legal method the court used to figure out when a promise is just talk and when it's a real binding deal. Okay, so here's our game plan. We're going to tackle this just like a lawyer would, using the FRAC method. We'll hit the facts, the issue, the rule, the analysis, the conclusion, and then the big takeaway for you. So let's get started.
First up, the facts. Let's lay out exactly what happened here.
You know, this whole thing really comes down to a single question. Was a promise to give up some so-called bad habits actually a legally binding contract? So here's the timeline. It all starts back in 1869. An uncle tells his nephew, hey, if you can stay away from drinking, smoking, swearing, and gambling until you're 21, I'll give you $5,000. Fast forward to 1875, the nephew turns 21, and he's done it. The uncle even writes him a letter saying, yup, the money's yours. But here's the catch. The uncle dies in 1887 without ever paying, and that's what leads to the lawsuit in 1891, with the nephew's assignee suing the uncle's estate to get that cash. All right, so we've got the facts down. Now, let's get to the core legal question the court had to wrestle with. And here it is. This is the big question. Did the nephew giving up things he was legally allowed to do count as valid consideration? In plain English, was this a real bargain that could make the uncle's promise an actual enforceable contract? Now, to answer that, the court had to bring out a huge concept in contract law. Let's talk about the rule of law here, defining consideration. So what the heck is consideration anyway? Well, the easiest way to think about it is as the price of a promise. It's the skin in the game for both sides. It's what makes a contract a two-way street, not just a one-way gift. Okay, the court used this classic definition from way back, and I want you to really focus on this because it's got two parts. It says consideration can be a benefit to one party, or it can be some kind of forbearance or detriment to the other. And that second half of the definition, that's everything. It's the whole ballgame in this case. So this is where the two sides really clash. The estate's lawyers argued, look, the uncle didn't get any real benefit from this. In fact, the nephew is the one who benefited by getting healthier. They're saying no benefit, no consideration, no contract. But the court basically said, nope, you're looking at this all wrong. The rule doesn't require a benefit to the person making the promise. All it requires is a detriment to the person receiving it. Okay, we have the rule, so let's get into the analysis and see exactly how the court applied that rule to the facts on the ground. The court's logic here is just beautiful in its simplicity. It's a four-step process. Step 1, what did the nephew actually do? He stopped drinking, smoking, etc. Simple enough. Step 2, did he have a legal right to do those things? Yep, for sure. Step 3, does giving up a legal right count as a detriment under the rule we just saw? Absolutely. That's the textbook definition of forbearance. And that leads right to step 4. Boom, the nephew provided legally sufficient consideration. And this quote from the court just nails it. The key isn't whether giving up these habits was good for him. That's totally irrelevant. The only point that matters legally, is that he gave up his freedom of action. He restricted what he was legally allowed to do, and he did it because his uncle promised him money. That was the price. And with an analysis that clean, the court's final decision becomes pretty obvious. So the court's holding was simple and direct. The nephew's forbearance, giving up his legal rights, was absolutely valid consideration. And that means the uncle's promise wasn't just a nice family gesture, it was a cold, hard, enforceable contract. And what does that mean in real terms? It means the estate had to pay up. They had to hand over the original $5,000 plus all the interest that had been piling up for years. The promise was finally made good. All right, so we've walked through the whole case. But what's the one big thing you need to lock in your brain from Hamer versus Sidway? Here it is. This is your key takeaway. Giving up any legal right you have at the request of someone else is enough to be consideration for a promise. It's not about benefit, it's about detriment. That act of giving something up, even if it's just your freedom to do something, is the magic ingredient that turns a promise into a contract. So, this case really hammers home that forbearance counts as consideration. But it also makes you wonder, right? What if the uncle made the promise after the nephew had already cleaned up his act? What if the good deed was already done? Well, that, my friends, opens up a whole new can of worms called
past consideration. And that's a story for another time.